Hello, and welcome to the housing section of the ULV Justice Center website. My name is Diana, and in this video, I'll be going over some of the basics of California's landlord-tenant laws. I will be covering the parties to a rental agreement, your rights as a tenant, and certain disclosures landlords are required to make before you sign a lease. A landlord can be a person or a company that owns a property and leases it to another person. This person is called a tenant or resident. The tenant has the right to the full use and possession of the property during the lease period. A rental agreement is a contract between the landlord and tenant, giving the tenant temporary possession of the property. Before signing any agreement, make sure that it has the following sections. It should have the names of all tenants. Every adult living in the rental should be named as a tenant and sign the rental agreement. This makes each one legally responsible for the property. It should also have the date the agreement begins, because the agreement will not be effective until this date. The agreement should specify that the rental unit is the residence of only the people who have signed the lease and their children. This gives you the right to determine who lives on the property. This can be valuable because it gives you the grounds to evict someone who moves in, like a friend or relative, without your permission. The contract should clearly state whether it is a rental agreement, which usually runs from month to month and is renewed unless ended by the landlord, or a lease, which sets a specific term, typically of a year. The landlord must give you at least 30 days notice before ending the tenancy. If you have been living there for a year, you are entitled to 60 days notice. Specific details about rent are important, like how much the rent is, when it is due, and if there's a grace period before rent is considered late. Also consider how the rent is to be paid, such as by mail or delivered to a specific address, and the payment methods, such as by check. To avoid any confusion or legal hassles about your security deposit, make sure the agreement is clear about the dollar amount and the use of the deposit. In California, the security deposit is limited to 2 months' rent, or 3 if the unit is already furnished. The landlord must itemize and return the deposit within 3 weeks after moving out. Clearly set out the responsibilities for repairs and maintenance of the rental. The tenant's responsibility is to keep the rental property clean and sanitary and to pay for any damage caused on purpose or through neglect. The landlord's responsibility is to keep the property habitable by taking care of important repairs, like broken heaters or plumbing issues. For more information about habitability, see our Living Conditions page. The agreement should include clauses for disruptive behavior, such as excessive noise or illegal activity. If the landlord does not permit pets in the rental property, the agreement should clearly specify this. If the landlord permits pets but under certain conditions, like size or number, these limitations should be written in the agreement. It is required by federal law that landlord disclose certain conditions before a tenant moves in. I'll go into more details on disclosures a little later. What the rental agreement cannot have is less than 3 days notice to pay rent, less than 24 hours notice for the landlord to enter, unfair late fees, a waiver of landlord's responsibilities, more than 2 to 3 months rent for security deposit, rent paid by wire or direct deposit, early lease termination fees, arbitration clause and jury waiver, and the excessive right to enter. As a tenant, you have certain legal rights that are always present, no matter what your lease may say. These rights include limitations on the amount of security deposit required to pay, limitations on the landlord's right to enter the unit, your right to a security deposit refund, the right to sue for violating laws or your lease, protection from retaliatory eviction, the right to repair serious flaws in the unit and to deduct the repair costs from your rent in certain circumstances, the right to withhold rent under certain circumstances, the right to a habitable home, and the right to disclose information about the unit. In California, landlords must disclose any of these issues to you before you sign the lease. If the landlord fails to make any of these mandatory disclosures, the lease may be considered void. The disclosures are for your own protection and education so that you can make an informed decision when choosing to rent a unit. In some properties, there may be a presence of lead or lead-based paint hazards. The landlord must disclose any known presence of lead-based paint and related hazards. Note that the landlord does not have to test for or remove any of the lead-based paint, but your lease must contain a lead paint warning in legal writing. If the landlord chooses to use periodic pest control, the pesticide company must provide the landlord with a written notice of the pesticides used on the day of treatment. The landlord must then provide you a copy of this notice. In some units, there may also be a presence of asbestos and mold, and it is strongly urged to make this disclosure whenever the presence of asbestos is discovered. It is also highly recommended that you ask the landlord if there are any known cancer-causing materials on the property. Remember that the landlord cannot intentionally misrepresent the unit to you. The production of methamphetamine can significantly contaminate the unit. If a local health official has deemed the unit to be contaminated due to the production of methamphetamine, the property will be considered unfit for use or occupancy and must be vacated until further notice. If you are a potential tenant, you must be given this information and acknowledge in writing that you understand the risks. The landlord must inform any potential tenants if a demolition permit has been applied for. The notice must state the expected demolition dates and the expected duration of tenancy. If you are a current tenant, the landlord must give you notice of the intent to apply for demolition before actually applying for the permit. The landlord must disclose if the unit has been approved for sale and is being sold to the public, that your lease will end when the unit sells, and that you will be given at least 90 days notice before the unit is offered for sale. If there is a closed military base where ammunition or military explosives have been used within 1 mile of the unit, the landlord must give you written notice of this. If there was a death in the unit within the past 3 years, the landlord must notify you of this as well. He is required to disclose the manner in which the previous tenant died, but not what illness they had or what they died. This has been a brief overview on just some of California's landlord-tenant laws. I would like to thank you for visiting the ULV Justice Center website, and I hope this video has been helpful and informative.